Welcome to today's program titled 2020 U.S. Election, the Biden Administration, Early Actions on Labor and Employment and How They Can Affect Employers. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the session that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed in the days following the webinar. On the next slide, you will see a legal disclaimer. And at this time, I would like to turn it over to Leon Rodriguez. Leon, please go ahead.
Good afternoon, everybody. Thank you for joining us to talk about the first actions in the area of labor and employment being taken by the new Biden administration. We have a terrific panel for you today. We are joined by Robert Fisher, partner in Seyfarth in our Boston office, Scott Hecker, who is in our Washington, D.C. office, serving as a senior counsel. Scott joined us just earlier last year from the Department of Labor, where he served both in the Occupational Safety and Health Administration and as an attorney for the Wage and Hour Administration. Next, we have another one of our Washington, D.C. partners, Larry Lorber. Larry is actually a former Assistant Secretary of Labor, served as one of the first directors of the Office of Office of Federal Contract Compliance, also known as Ofccp. And finally, to make sure that we have a coast-to-coast presentation today, we have our good colleague and friend, Scott Mallory, who serves as a counsel in our Sacramento office. And again, I'm Leon Rodriguez. I'm a partner in Washington, D.C., and the former director of U.S. Citizenship and Immigration Services. Next slide, please. We're going to cover a lot of territory today. Actually, what you see here may only be a part of what you're going to get. We're going to cover a lot of issues. We're going to talk first about some of the agency appointments that we've been seeing, particularly in the Department of Labor, but also in other agencies that touch on both labor and employment issues. We're going to talk about some of these early diversity and equity actions you've seen coming out of the White House, Ofccp, which I mentioned earlier, Nlrb, which will be covered by Robb. You'll hear some discussion of the minimum wage by Scott Mallory. And finally, the preparation for an OSHA COVID-19 emergency temporary standard, which will be covered by Scott Hecker. Next slide, please. So I often talk about, and you certainly hear here in Washington, D.C., about the idea of personnel being policy. Who you place in charge of various functions, and also who you place in charge specifically of making policy will tell you a lot about what that policy will be and how that policy will be implemented. And so the first place we saw this, and we're just going to talk about this real quick because we're now several weeks into the new administration, but on the next slide, you will see the composition of the transition team. And there's a couple of things, you can look at the names yourselves, but there's a couple of things that I would point out. First of all, as you look down the list of who was on the transition team until Inauguration Day, you will already see some people who are now parts of the administration. So you see Patricia Smith, who was counsel to the Secretary of Labor, Jenny Yang, now the head of the Ofccp, Ann Rosenthal, who was another senior counsel to the Occupational Safety and Health Administration, and probably others yet who will be joining the administration in the months to come. You also want to look at what they were doing at the time that they were participating in the transition team. You'll see a number of individuals who were affiliated with labor unions, with employee advocacy organizations, not to mention a number of consultants who also support labor unions and these organizations. So in the next slide, you'll see the first and most, obviously in this area, the most significant appointment, and it's Mayor Marty Walsh, the mayor of Boston. His nomination was announced well before Inauguration Day on January 7. Mayor Walsh is he's an organized labor veteran. So before he became mayor, he was the head of the Boston Building and Construction Trades Council after he entered public office. He was elected mayor of Boston in 2013. He played other labor union roles as well. We've talked a little bit to our colleagues in Boston about Mayor Walsh. Actually, I'll be interested to hear what Robert has to say. But the sense was that he is somebody very much rooted in the organized labor community. His views are very much the product of that experience. But at the same time, he's seen as somebody who is pragmatic and is open to listening. Time will tell where he lands, but we did think it was worth sharing that little bit of intelligence. The next is in the next slide, you'll see the expected nominee to be Deputy Secretary of Labor, Julie Su, who is the Secretary of the California Labor and Workforce Development Agency, more or less that state's Department of Labor. She comes from the advocacy community, having founded Sweatshop Watch, being the litigation director at the Asian Pacific American Legal Center for Southern California. One possible hitch for potential nominee Sue is the scandals that beset the California unemployment program, claims of fraud and mismanagement during the time that Ms. Sue served as Secretary of the department. In the next slide, you have Patricia Smith. This is Ms. Smith's appointment is something generally to watch as you look at federal agencies. So Patricia Smith previously had served as the Solicitor of Labor at the Department of Labor in the Obama administration. She's a former New York State Commissioner of Labor, and now she is serving as Senior Counsel to the Secretary of Labor. What does that tell you? That tells you that she is the eyes and ears of the White House in the building. When you have somebody of that stature serving in a role like that, you know that that is somebody who is trusted by the White House, and in particular where you have somebody like Mayor Walsh, who is really an outsider to Washington, not necessarily schooled in its norms. You have individuals like Patricia Smith who are there to make sure that the White House's policy vision is implemented. Just a couple more to share. Next slide. Expected head of OSHA nominated as Deputy Assistant Secretary of Labor for OSHA, James Fredericks, coming from the Steelworkers Union. I imagine Scott Hecker may have a couple more things to say about him. And in the next slide, we have Jenny Yang, previously chair of the EEOC, part of the transition committee that I described earlier, and now director of Ofccp, an agency that in the last months of the Trump administration got a lot of attention. We can expect her to be focusing on pay equity and sexual orientation and gender identity rights. And finally, in the next slide, I believe we have the acting general counsel of the NLRB, particularly notable because of the controversial dismissal of former NLRB general counsel Robb by the White House that led to some questions as to whether that was a permissible hire. He is acting general counsel, Mr. Orr. That means that he is likely ultimately to be replaced by a White House appointee, although the timeline for that is unknown at this time. And next slide, please. And with that, I'm turn over to Larry Lorber to talk about the diversity and equity actions that you have seen during the transition and now in the Biden administration.
Thank you, Leon. If you could go to the first slide, Kelly. What I want to do is begin by simply talking about a couple of the Trump initiatives, simply because these will put into context what what the president and his folks are doing now, very early in their administration, and what the implications might be for diversity and inclusion. First of all, what I'd like to do is focus a bit on the Trump administration in September issued two, as I'm sure you know, two fairly dramatic pieces of policy implementation. The first was an OMB memorandum issued on September 4th, which directed the federal agencies which conduct federal training, employment training, and other types of activities, that noting that they could not in that training discuss white privilege, cannot make an assumption in their training that there is embedded racism in the United States. None of that could become part of the training. And that was followed on September 25th by Executive Order 13950, where the president used his procurement authority to forbid government contractors, as well as federal agencies, from using race or sex stereotyping as a basis not only for training but for policy. So that the executive order repeated much of what was in the OMB memorandum, stated that both training and enforcement cannot be predicated on race or sex stereotyping as a basis for policy or enforcement actions. It also directed the procurement agencies to collect, though it was voluntary on the part of contractors, to collect their training materials, to review them, Ofccp in particular, to review them to determine if their training materials contained any of these types of representations that the Trump administration believed were improper. And not only that they believed them to be improper, but the executive order also directed the Justice Department, which was the substantive sort of act here, to interpret Title VII in accordance with the policy, which meant that even though the Justice Department only has enforcement authority in the public sector, it is, as you know, the government's main legal department, and it does set policy in a manner for the enforcement agencies. In our context, the Ofccp, part of the executive branch, and the EEOC. So the Trump memorandum and the executive order were major diversity initiatives and caused, as some of you might recall, a great deal of consternation among the contractor community, the community that deals with Ofccp, because much of their training programs had already been booked for the year. This was September, and many training programs, as you know, talk about concepts such as implicit bias, which was also banned by the executive order, as well as other concepts which make assumptions that the definition of discrimination is not a clear and plain intentional discrimination, but can represent societal beliefs, mores, other types of things. And these executive orders and memoranda prohibited not only the discussion of those, but prohibited the implementation, really the utilization of those concepts in enforcement. And as I said, the executive order also directed the Justice Department to interpret Title VII in accordance with the policy. Now, that's very rare Leon and others could talk about it. I'm unaware of the White House telling the Justice Department how it shall interpret the law, but that did happen. Next slide, please. Well, let me go back. One other thing that the Trump folks did was they brought a lawsuit against Princeton University, against Yale University, claiming that Yale's admissions policies were, this would be the third slide, Kelly, I'm sorry. Yeah, they sued Yale University, claiming that Yale's admission policies discriminated against Asian Americans and whites, Caucasians, by creating preferences for Black and brown applicants and other Asian applicants, but not from North Asia. This was a very unique litigation. Some of you might recall previously in litigation involving the University of Michigan, where admission policies were challenged in the early 2000s and on the basis of racial preferences, and the Supreme Court sort of split the baby, but upheld the use of a holistic use of race and sort of economic deprivation and other standards to permit those concepts to be considered in admissions. The lawsuit against Yale was a direct attack on that and was very unique. That the Justice Department did that was a very unique experience. In Princeton, the administration directed the Department of Education to investigate all of Princeton's diversity initiatives, so that they were looking not only at their admissions, but looking at their hiring of faculty and looking at other activities that Princeton undertook, which emphasized or encouraged diversity. Again, this was very unique. We could now go back to the previous slide, if you could. Well, January 20th came along, and what happened? On January 20th, I think it was the second executive order that the president signed. I used to say in between the swearing in and the lunch at the Capitol, there was a swearing in, and then there was a sort of a picture presentation at the Capitol. President Biden signed several executive orders. Two of them are relevant to what I just discussed. Executive Order 13985, January 20th, 2021, rescinded the Trump executive order, rescinded Executive Order 13950. And the Biden executive order required federal agencies to promote diversity in training and policy. And the Biden executive order directed that the Domestic Counsel, an agency out of the White House, would take the lead in ensuring that the federal agencies, both in their internal training programs, in the training they offer to their stakeholders, which, as you know, several do, and in terms of their enforcement policy and policies generally, emphasize diversity and emphasize the need, both as a policy matter and as a legal matter, to promote and encourage diversity in all aspects of training. President Biden also issued Executive Order 13988, also on January 20th, and that prohibited discrimination on the basis of sexual identity and orientation, directed all federal agencies to examine all policies and regulations to prohibit discrimination on the basis of sex orientation and identity. Subsequent policy initiatives coming out of the White House, for example, reversed the Defense Department's prohibition on enlistment and retention of transgender individuals in the military, and that's been taken away. And two executive orders, 13985 and 13988, directly reverses the Trump policies on diversity and inclusion. very quickly, you're hearing a lot about executive orders, and they're coming fast and furious. They did under the Trump administration, and they're doing it under the Biden administration. As a legal matter, executive orders do have the force and effect of law, except unlike statutes, they can be rescinded by the next president. And as you see, a September executive order was rescinded in January. And by doing that, that wipes out the force and effect of the executive order, and indeed wipes out any regulations which would have been issued pursuant to an executive order. Just as if a statute gets rescinded, any regulations under the rescinded statute are null and void as well. So what we have is, in the absence, or at least both in the Trump era and certainly now, the difficulties of Congress. As you know, today the Senate's doing impeachment. It's not doing legislating. Executive orders are the means by which policies are inaugurated and policies are implemented. I point this out because we're about to get to Ofccp, and the basis of Ofccp is indeed an executive order, 11246, issued by President Johnson in 1965. It's been attacked frequently, subject to litigation frequently. I'll talk about that momentarily. But it is still in force and effect, and therefore the basis of Ofccp, not on disability or veteran status, but on race and gender, is an executive order, can be rescinded by a president by the stroke of a pen. And yet, as we're about to find out, and as I'm sure you all know, the Ofccp has a very long history. Its current incarnation is as of 1968, though the executive order was 1965. There's no sign that it's going away. The Supreme Court addressed it several times. They talk around it and about it because I think the court is sort of unsettled in some context of an executive order having this reach. But nevertheless, that executive order is there. So with that, if we could go to the next slide, we're going to talk about Ofccp. As Leon said, I was privileged to head the agency a long time ago. It covers about 25% of the workforce in the United States. That is, workers, employees who work for federal contractors or subcontractors. It is the basis for affirmative action and the basis for affirmative action regulation. I just want to give you one historical note. Some of you may have read, but to some of the others who have gray hair and been around a long time, former Secretary of Labor George Shultz died this weekend. He was 100 years old, one of the only two people who have held 4 cabinet positions. But he was the Secretary of Labor under President Nixon, and in 1969, when he became secretary, he put into place something called the Philadelphia Plan, and indeed created Ofccp as you know it today. And indeed, it was stated in the various obituaries written about him, including by Condoleezza Rice and others, that Secretary Shultz looked to his time at the Labor Department and his work on behalf of non-discrimination as one of the highlights of his career, which is really amazing if you think about it. He was a labor economist, so he knew a lot about the labor market, and much of what you see in Ofccp, and I could tell you this, really emanated from then Secretary Shultz's writings and what he wanted the agency to do. Well, that was a long time ago. Now we're going to talk about what the agency is going to do now. As Leon pointed out, the new director of the Ofccp is Jenny Yang. This is an interesting appointment. She previously, under the Obama administration, was the chair of the EEOC, and she has a long background in civil rights and enforcement. I would say it was a promotion. Others, because she's the director of the Ofccp, others say it's sort of quizzical that she went from the head of an independent agency presidentially confirmed to the head of a sub-agency in the Labor Department appointed by the president or the secretary if there were a secretary there. Why is this important? Well, you look to Jenny Yang's policies at the EEOC to try to see what her policies will be at the Labor Department. And even though on the hierarchy of government life, her job at the EEOC was probably higher and more prestigious, her authority at the Labor Department is greater. She doesn't have a commission to have to deal with. In fact, the current commission, even though Charlotte Burrows is the chair, has 3 Republicans and 2 Democrats as commissioners, so there'll be limits as to what the new chair, Burrows, can do over there. Jenny Yang, as long as the secretary and the White House agree with what she does, has a pretty free rein in what she does over at OFCCP. As the slide says, the Department of Labor and the OFCCP really will be the engine of change for the Biden administration. What does that mean? Many of his policies that have been issued via executive orders in the last 2 weeks, many of them cover government contractors. The president has fairly absolute authority in the world of procurement to determine what the government buys, on what terms it buys things, and from whom it buys things. So even though OFCCP will not deal with the Buy America Act, the Labor Department, along with the procurement agencies, will. So where do we think Jenny Yang is going to put her emphasis on? I think there are a couple of areas. First is artificial intelligence and recruiting. It's an area that's been growing dramatically. It's using online computerized, or I'm dating myself, artificial intelligence to determine skills and background of potential employees, rating them, and making determinations or recommendations as to who should be hired. That is all subject to the law because it still is hiring, whether it's AI or somebody posting jobs on a bulletin board. At the end of the day, you're considering applicants and determining who to hire. And the use of artificial intelligence determining whether or not the policies that the AI programs are putting into effect, the algorithms and all the rest, will be subject to review, and it can be expected that the OFCCP is going to take a lead on that. Compensation data transparency, Jenny Yang promulgated, fought for what was known as Component 2 of the EO1 data collection obligations, and it can be expected that she will use her authority at the OFCCP to go in that direction. Indeed, before she, in 2015, put into effect Component 2 of the EO1, the Labor Department had published its own compensation reporting obligations for government contractors, which was indeed more inclusive than the Component 2 stuff. Jenny Yang is now at Labor, and one could certainly expect she's going to focus on that, along with systemic pay analyses. That's going to be a subject of obvious activity, and then they're going to move, I believe, from education and compliance assistance to enforcement. Very quickly, I want to point out that at the end of the Trump administration, they signed what was called a Memorandum of Understanding between Labor, Justice, and the EEOC, which really gave Justice a lead role in establishing employment discrimination policy. As I noted, that was done in the Trump order on diversity. Well, now this Justice Department under Merrick Garland and under the people who have been announced as nominees for Assistant Attorney General for Civil Rights will have an importance beyond Justice's historic importance, and I'm sure will work consistently with Jenny Yang. As I said, 13950 has been rescinded, so all of that stuff has been withdrawn, and President Biden has issued 13988. I think in summation, it can be expected that the OFCCP is going to be extremely aggressive. As Leon pointed out, Patricia Smith, who was solicitor in the Obama administration, is back as a senior counsel, senior advisor. She'll obviously have a major role. She did in OFCCP back in those days, and it's expected that along with Jenny Yang, this is going to become an extremely aggressive and important agency for itself and as a model for the use of procurement to establish policy. With that, let me pass this on. Kelly?
Hi, everyone. Sorry about that. Hi, everyone. This is Rob Fisher. I'm a partner in the Boston office. And just a comment on Leon's comments about Mayor Walsh. I agree with the scouting report. The one thing I'd add is I hope that his experience running a major city, including having to negotiate with the city's unions, will help temper some of his own labor background as he runs the DOL. But I agree that he is a pretty pragmatic guy generally. So for about the next 10 minutes, I'm going to talk about what's happening on the federal labor law front. As Leon commented at the beginning, we have a new acting general counsel, Peter Orr. And Kelly, next slide, please. And as Leon intimated, the termination of General Counsel Peter Robb and the appointment of Peter Orr was pretty controversial. And I actually think it's helpful because I think it gives you a sense of where the administration is on traditional labor law and union organizing. So Peter Robb was a Trump appointment as general counsel. He was serving a 5-year term, which was set to expire in August of 2021. So he was supposed to be general counsel for the next 7 months. On inauguration day, so day one of the Biden administration, he was asked to resign by 5 p.m. Peter Robb refused, and by 8 o'clock, he was terminated. None of that was, the process is a surprise. So as far as I know, this is the first time in the history of the National Labor Relations Act that a president has removed the general counsel before his term is set to expire. So that piece of it is dramatic, but Peter Robb was viewed with, I don't think this is an overstatement, with extreme hostility by labor unions across the country, including within the Nlrb itself. And so the removal of Peter Robb as general counsel, literally on the first day of the administration, I think really sets the tone as to where the administration is on these issues. And I don't think it's really a surprise given what President Biden was saying on the campaign trail. Next slide, please. These are some of the quotes that we've called from President Biden as a candidate as well as president-elect. And the theme in all of these quotes is the idea that the president is committed to supporting and growing the power of organized labor as part of his administration. And I think the place that really begins is with a piece of legislation or proposed legislation called the PRO Act. Next slide, please, Kelly. PRO stands for Protecting the Right to Organize. So the name by itself should tell you a lot about what it's going to do. This was actually, it's been proposed a number of times. It actually passed the House last year, but went nowhere in front of the Republican Senate. And it was reintroduced in Congress a few days ago. So I think this is now a central piece of the administration. And to put it bluntly, this would be a dramatic change to the National Labor Relations Act as we've known it. And it effectively consists of a wish list for organized labor. I'll give you just some of the highlights. There's a lot in there that would change the way in which unions organize and how employers interact with unions, but just some highlights. First of all, it would codify the Obama era joint employer test from the Obama board, which many of you may remember out of the Browning-Ferris decision, would increase who can be a joint employer for purposes of federal labor law. The Trump board had promulgated a rule which narrowed that, and this law, if enacted, would essentially override the Trump board's rule on joint employment. It would take the ABC test, which is a very stringent test for employees versus independent contractors, and adopt that's used in some states, including my home state of Massachusetts, and take that and apply that to federal labor law. It would override state right to work laws. From an enforcement perspective, which I think is really interesting, the unions have often complained that the labor board doesn't have a lot of teeth whenever an employer violates the act. Well, the PRO Act would change that. The PRO Act would allow the board to impose monetary penalties, not just the traditional remedies that it would use to enforce violations of the act. Those monetary penalties could be enforced against corporate directors as well as corporate officers, as well as the companies themselves. It also would allow employees to bring a private right of action under federal labor law if, in fact, the labor board the general counsel didn't pursue a case through the board process. It would require the board to seek injunctions against employers for firing employees that the union alleges were fired for union activities. So all of this would dramatically change how we've always understood the labor law to work. Obviously, its success probably turns in the Senate, so stay tuned on all of this. If they don't have the votes, if the Democrats can't get it passed, then I think we would expect a Democratic board to do what we saw the Trump board do in response to the Obama board, which is attempt to change the law through rulemaking. So we would expect, for example, that a Democratic board appointed by President Biden, I'll talk a little bit about the who's on the board right now and when we think that's going to happen in a moment, but essentially we would expect to see new rules regarding election processing. The Obama board had put forth what are known as the ambush election rules or the quickie election rules, which were designed to make union elections to happen really quickly and make it difficult for employers to campaign against unionization. The Trump board then reversed that with its own set of rules. I expect through rulemaking, we would see the same sort of thing from a Biden board. Similarly, I would expect a new rule on joint employment, which is intended to reverse the Trump board rule, assuming, of course, there's no pro act enactment. So that's what I would expect to see. The other place would be changes in case law, which I'll talk about in a moment. Next slide, please. So currently there are five members of the board. There are currently 4 board members. There's 1 vacancy. There are 3 Republicans and 1 Democrat. Member Emanuel, who's a Republican, his term is expiring in August of 2021. So we would expect President Biden to be nominating 2 people to fill those seats, presumably Democrats, so that we would have a Democratic majority once the Senate approves his nominations, presumably by August into the fall. At that point, then we'd have a Democratic majority, which would then be deciding cases, presumably in panels of 3, with 2 Democrats, 1 Republican. Next slide, please. That's not to say that everything is status quo until then. As Leon mentioned, we have an acting general counsel, Peter Orr. At this point, we don't know who's going to be the nominee for general counsel, but acting general counsel Orr has already rescinded a number of memoranda issued by Peter Robb. It's a subtle but important change. The general counsel is essentially the prosecutor of the NLRB. His office, through the regions across the country, decides what cases get brought and get prosecuted. And so effectively, the memoranda are used to advise the regions as to when to issue complaint and versus when to dismiss a complaint. So these changes, by pulling the Peter Robb memoranda, he's effectively sending the instruction that whatever policies that Peter Robb was promoting are not what the region should be doing going forward. So we would expect to see that the acting general counsel will be changing policy in terms of what cases will go to complaint. And then what we'll see is the board issuing decisions that would effectively change some of the decisions from the Trump board, which the Democrats disagree with. And just to highlight a couple where I think are the major changes that are coming. First off, Many of you probably remember Obama-era decisions dealing with handbooks and policies, where the Obama board took what I would take a hyper-technical view of language and determine that the language might be read to interfere with employee Section 7 rights, and thus the policy was illegal. The Trump board had taken a more pragmatic view, looking at a policy as a whole and trying to determine whether someone reasonably would read it that way. And I expect that we're going to go back to the Obama era standard. And so for those of you that altered your policies during the Trump board period, because under the Boeing standard, I think you should start thinking about, do you need to review your policies and handbooks to go back to the kind of language that we were recommending under the Obama board. I also expect the Biden board will go back to the specialty healthcare standard for organizing. Specialty healthcare effectively was a decision that made it easier for unions to organize very small groups within an employer and essentially gather a foothold, which changed the way in which what would be an appropriate unit for bargaining. And then another one I'll just highlight is, I assume we'll go back to the Obama board era rule that would require an employer to bargain with a union over employee discipline and discharges immediately after an election, but before negotiation of a first CBA. So the bottom line is, I think some of those cases that tend to flip-flop from one administration to another, we're going to see all of that. But I do think that this administration has signaled an intent to be supportive of organized labor. And so I think it's going to be what we saw under the Obama administration, but more. So at this point, I'm going to turn it over to the next speaker. Thank you.
Thanks, Rob. This is Scott Hecker. I'm going to speak a bit about federal workers and federal contractors for 15, which I meant it to sound like Fight for 15, came off sounding a little bit more like a Jeopardy answer when I read it, but we will talk about that, the executive front, as well as Scott Mallory will then talk about legislative pathways to the $15 minimum wage. So we did already have an executive order, 14003, requiring the director of OPM to provide a report to President Biden with recommendations to promote a $15 per hour minimum wage for federal employees. Also released was the direction by President Biden to his administration to start the work that would allow him to issue an executive order within the first 100 days, which I believe we'd be looking at the end of April with that requires federal contractors to pay a $15 minimum wage and provide emergency paid leave to workers. So you heard Larry talk about the size of the federal contracting workforce, and if you add federal employees on top of that, you're talking about a lot of folks who could be subject to that $15 minimum wage through these executive actions. Of course, there is already a minimum wage in place for federal contractors. President Obama in February of 2014 issued EO 13658, which at the time had a minimum wage, I believe, of $10.10 an hour. It's now been adjusted up annually, and most recently, it made it through the Trump administration, and most recently, the effective rate was $10.95 as of January 1st, 2021. So we will see how those executive orders, basically the direction to figure out how to take action from President Biden, play out over the coming months. But for now, I'll turn it over to Scott Mallory, who will talk a bit about the legislative side.
Thanks so much, Scott. I appreciate it. It's interesting. I think that those executive orders are kind of like pushing the policy agenda, and hopefully I think that they want this to move into the legislative space. Funnily enough, and my apologies for the shameless plug here, but the government relations team started doing a podcast, and during the very first episode, Leon Rodriguez, who's here presenting, told me that he would bet at his top dollar that the minimum wage would be the #1 LME issue to come up. So kudos to you, Leon, for that. So I guess, and here we are. I mean, at the time that the administration started, we didn't know the minimum wage would be as huge in the news as it is, but anyone watching knows that it's all over the news right now. So really, what are the mechanisms and what is the likelihood this minimum wage hike can pass through some kind of legislative function? The reporting on this has been kind of like the stimulus was in March through December. It teeters all over the place. So at one second we're going to have it through legislation, the next second we're not. I mean, in the beginning there was all this talk about bipartisanship. Indeed, I'm sure a lot of the listeners here saw that, excuse me, 10 Republicans come to the White House to talk with the president, but the reporting lately has been much more that they're going to do this without the Republicans and try to go at it alone. Indeed, so the entire argument, right, has been whether or not they're going to be able to get this through on reconciliation without any Republican support. So just last Friday, the president announced during an interview that he didn't think the minimum wage hike could come in a pandemic process because of what he termed procedural barriers. Excuse me. Obviously, he's referring to reconciliation, which would allow Democrats to pass the measure without Republican support. But I think he's more specifically referring to the Byrd Rule, which at its core prohibits provisions in a reconciliation bill that are viewed as extraneous to the budget or would increase the budget deficit beyond the 10-year window. Just yesterday, though, the Congressional Budget Office released a report concluding that raising the minimum wage would actually increase the U.S. deficit by $54 billion over 10 years, and it would reduce employment. So that report, at least in the eyes of Budget Chairman Bobby Scott, and probably the most important one, the Senate Budget Chairman Bernie Sanders, have both stated that they believe the CBO's numbers make it more likely that this could pass through reconciliation. So right now we have a Senate reconciliation bill that does not have an increase in the minimum wage, which is specifically because what's termed the vote-a-rama, Senator Joni Ernst offered an amendment basically saying that there can be no increase in minimum wage during the pandemic, and that got full approval from the Senate, including Senate Budget Chairman Bernie Sanders, who is 100% certain that this can pass through reconciliation. So there's a lot of political posturing and sort of things going on both sides, which makes this really confusing. I mean, and so we said that the Senate version of the bill doesn't have that minimum wage hike, but the House version of the bill, which passed by a purely party line 218-212 vote, does have the increase in the minimum wage in it. So it's just going to be interesting to see how that reconciliation process plays out. I think the way the reporting has been going so far, it looks like there's not going to be a minimum wage increase in sort of stimulus package right now. So a lot of moderate Republicans like Lisa Murkowski and Tom Reed of New York have urged President Biden to split this minimum wage hike from this COVID-19 package so that he could push a standalone measure. So, you know, even if raising the wage can't get past these sort of procedural and I would say actually more political challenges, then they also introduced a standalone bill called the Raise the Wage Act, which would phase in a $15 minimum wage by 2025. You know, regardless of which legislative machination this is enacted through, I think that employers should prepare for some kind of a hike in the minimum wage. Goldman Sachs recently did an analysis in which they put forth that they believe either $10 to $11 or $12 minimum wage would probably be more likely to pass. And I know that this is purely anecdotal, but I've heard from a lot of those in the business community who believe that an increase in the minimum wage would be welcome, but are adamant, apologies, that an increase to $15 an hour is way too much and fails to account for geographical variation. So we're going to keep following this. I think mid-March is the date that everybody should be looking to see if this sort of drastic hike in the minimum wage is done through this pandemic process, or it goes through later. One thing that I think that people should be mindful of is that this reconciliation process, usually it can only be done once a year, but the Democrats this time are going to get 2 bites at the reconciliation apple because in fiscal year 2020, it wasn't done. So there is a chance that they can do it again later, but there are so many crises happening right now that this is a legislative issue that's going to be hard to get past. But I would say expect something to happen and stay tuned. On that note, I will pass it back to my good friend, Scott.
Thanks, Scott. If we could go to the next slide, Kelly. So before we get into whether the OSHA ETS, I wanted to give you the CLE code for today's program. It is SS, as in Seyfarth Shaw, 2275. Again, SS, Seyfarth Shaw, 2275. And we can go to the next slide, Kelly. So during President Biden's first full day in office, we saw another EO laying the groundwork for further action. He issued Executive Order 13999, directing OSHA to consider whether an ETS is necessary, a COVID emergency temporary standard is necessary, and if so, to issue one by March 15th. We haven't heard anything official from OSHA about what kind of analysis it's undertaking to determine necessity. Nor has OSHA commented on whether it's determined one is necessary. I can tell you I fully expect that they're well on the way, a little more than a month out of that March 15th date to working on this. You have a number of people who are involved, heavily involved in OSHA on the task force, like Dr. David Michaels. You saw Doug Parker's name on the transition team list. He's the head of Cal OSHA. Julie Su being the secretary of basically the California DOL. California has a very, very strong ETS that many of us hope will not be the model for the federal version, the anticipated federal version. So we're keeping an eye on that, and we'll see whether OSHA says anything before March 15th, but I would fully expect that there will be an ETS issued. Also in that EO, the 13999, President Biden required that OSHA review and revise its COVID-19 workplace safety guidance, which it did on January 29th. It published Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. And the purpose of that revised guidance is to put forth stronger work safety guidance to help employers and workers implement a coronavirus protection program and better identify risks, which could lead to exposure and contraction. If we could go to the next slide, Kelly, we'll talk a little bit about what is in that revised guidance. There were 16 items listed in the guidance, described in that guidance, that OSHA believes the most effective COVID-19 prevention programs include, and they took a deeper dive into some additional highlights, key measures they identified that include, separating ill folks, getting them home and out of the workplace as soon as possible, implementing physical distancing and installing barriers, using face coverings, providing supplies for good hygiene practices, and performing routine cleaning and disinfection. Now, what this guidance is not is enforceable. In fact, Ann Rosenthal, who we mentioned earlier, OSHA senior advisor, who was in the solicitor's office, the associate solicitor for occupational safety and health, previously indicated that OSHA does not enforce guidance. So this isn't a substitute for an ETS, but I would definitely view this as providing clues to what may end up in an emergency temporary standard. Leon mentioned Jim Fredericks earlier, who's been named as the Deputy Assistant Secretary for OSHA, so we can be sure that unions will have a direct line of input into the ETS as well as other OSHA issues. We should also consider item number 15 in that effective prevention program list included language that read, not distinguishing between workers who are vaccinated and those who are not. So we're continuing to keep in place mitigation risk protocols, and CDC and OSHA haven't really moved to say, as vaccinations increase, what will changes in other protocols look like? But that's something certainly to keep an eye on. With this guidance out there, though, I would say now is the time to review and revise your COVID-19 plans and take a look to implement appropriate mitigation protocols based on what OSHA believes, or OSHA has stated it believes the most effective COVID-19 prevention programs include. You can that way hopefully get ahead of the ETS and when it becomes binding regulation, as opposed to now when we're looking at guidance. Again, it's an issue that's going to continue. OSHA will need to consider how the wider spread of vaccination impacts the risk of COVID in the workplace, and how we can sort of balance pre-existing mitigation protocols and how those will evolve over time. But for now, certainly keep your other risk mitigation protocols in place. There's some other interesting logistics around an emergency temporary standard. If you have questions about them, feel free to reach out, but I won't burden you with them now since we have about 2 minutes left. I'm going to kick it back to Leon.
Leon, you might be on mute.
Yep, I was muted, but I got ahead of you. So next slide, please. I just want to say two quick things about immigration. One, on the next slide, you will see a reference to America's Citizenship Act of 2021. This is the centerpiece of this act is a provision to provide a path to citizenship for dreamers, DACA recipients, and other undocumented persons. But it also contains a lot of other stuff, some of it of significant consequence to employers, including, in addition to the legalization for undocumented, potential legalization path for temporary protected status recipients, talking about over time as many as 12 million people who could become part of the permanent legal workforce in the U.S. And then at the bottom, important to pay attention to what's going to be happening in worksite enforcement. You're not going to be seeing some of those raids you were seeing during the Trump administration. You are, however, likely to see a continued high level of focus on employers rather than employees. In other words, you'll keep seeing I-9 inspections, investigations, rather than the sort of deportation-focused approach to enforcement that you saw under Obama. So just a couple, I'm sorry, under Trump. So just a couple things to watch in terms of immigration. I think we've cleared all the questions in the chat box. So as we head to the top of the hour, I am going to say thank you. Any final words from, since we do have about 2 or 3 minutes, any final words from the other panelists? Larry Lorber, I had a question for you. You know, when we were talking about the diversity and equity actions in Ofccp, you know, it's clear that right now those are focused on federal contractors and, of course, the federal government itself. And I think one question that folks have is whether some of those efforts, or how they're going to affect private employers who are not federal contractors. Are these initiatives things that could change the landscape for them?
Yeah, they can. I think as I noted, a lot of this is coming out of executive orders covering procurement. Others, however, are going to reflect Justice Department policy. And what I can envision is seeing policy pronouncements, which would certainly lend itself to private litigation, and also to encourage states and localities to get active. They have been quite active over the last 2 years. I assume they're going to become more active, even though the Democrats are in control if Garland when he gets confirmed, and the other folks at Justice. So there's that. The one holdup will be possibly the EOC. There's a Republican General Counsel, and unlike Peter Robb, I don't know that she's removable. And if she's not, she's going to be there for about another 1.5 years if she stays. And Janet Dillon, the chair, her term doesn't run out until the summer of 2022. So there will be a Republican majority on the EOC. So, long answer to a very short and good question. I think you're going to see policy pronouncements coming out of labor, policy coming out of justice, probably none out of the EEOC, or I doubt any, but nevertheless, it's going to encourage diversity activity by the private sector, non-procurement, and also encourage state localities, NGOs, private activity by advocacy groups to enhance diversity activity.
Okay, great. Thanks, Larry. So with that, we're at the top of the hour. I want to thank everybody for joining us today. One thing that I do want to remind you is continue to watch your email boxes and our website. We're going to continue as developments unfold with this new administration and, of course, the new Congress. We're going to be coming at you with podcasts, webinars, articles. Of course, we have our biweekly Policy Matters newsletter edited by Scott Mallory. So we're going to be making sure to keep you all informed about the latest developments in labor and employment as we're in a time of change, as they say. So with that, thank you. Everybody have a nice afternoon, and we'll look forward to seeing you again soon.
This concludes today's webinar. Thank you for attending.